the e-lecture series organized by the Colombo Law Society. I'm Vijay Gamage. I'm the president of the Colombo Law Society. Colombo Law Society presently has a membership of around 4,000 and is the largest branch association of the Bar Association of Sri Lanka. Our vision is to make a strong and independent bar. This e-lecture series also one of such events to enhance the knowledge of our membership as well as the legal fraternity. Our seminar subcommittee was originally organizing a series of seminars. However, due to the COVID-19 pandemic, we have to come up with this e-lecture series. This is the 5th e-lecture of the series, and past e-lectures have been very successful. I would like to thank the organizers of this e-lecture series, the co-chairs of the seminar subcommittee, Mr. Sanath Karuranathan and Mr. Chatura Galhena, our treasurer, Mr. Nalin Samarakon, and the organizer, Mr. Imas Mithias. I would like to specially thank Mr. Chatura Galhena and Imas Mithias for taking the initiative in conducting today's e-lecture. We will be having e-lectures on every Friday. And apart from that, we have organized another webinar series for the juniors and the apprentices. That webinar series will be starting from next Tuesday. I invite you all to join with us in our webinar as well as our e-lecture series next week as well. Now, I invite our moderator, Mr. Chatura Galhena, to introduce today's speaker and the topic. Thank you.
Thank you, Mr. President. On behalf of the Colombo Law Society, I welcome you all to the 5th webinar conducted as a series started about a month ago. And today, our lecturer is Mr. Priyal Wijayaweera, President's Counsel. Talking about Mr. Wijayaweera, he's a civil practitioner, very senior civil practitioner who's having a practice of over 35 years. And he has started his practice in Matara in early 1980s, and with the move to Colombo, he has confined to civil litigation, which he has in Matara. He has involved in both criminal and civil litigation. Mr. Wijayaweera's main areas of practice involves all type of civil litigation, mainly in the areas of Mount Lavinia, Colombo, Nugegoda, Omagama, and other areas. Mr. Wijayaweera has a vast experience in drafting pleadings, and also he will discuss mainly today what are the key ingredients or key items that lawyers or the attorneys must consider in drafting pleadings. Rather, when a client comes, how you should decide what type of action to be filed and what is the procedure that you should follow in deciding and presenting your story, client story, to court. Mr. Wijayaweera was appointed the President's Counsel in the year 2017 in recognizing his long and dedicated service to the profession. Especially, Mr. Wijayaweera agreed to do this lecture only 2 days ago because we had a technical issue early this week, and it was not confirmed earlier whether we are going to have this today or not. And when myself and President Mr. Gamage invited, Mr. Wijayaweera without any hesitation agreed to do this with a very short notice. And I thank you for that commitment and help that you have extended to the Colombo Law Society. Without taking much time, I will now invite Mr. Wijayaweera to commence his lecture, and please be free to post your questions on the Q&A tab, and we will be answering those questions, or we will be discussing those questions at the end of the session. It is over to you, Mr. Wijayaweera.
Thank you, Vijaya. Thank you, Chatura. Thank you for the kind words you have said. Actually, as you said, I was given only a very short period of time, and this topic is instituting civil actions, things to be done, things to be considered, which is of a very vast area. So with the little time, I think I managed to get as much as possible, and I'll try my best to make it useful to you within the period I'm given. So anyway, at the commencement, I should like to say that this is an area, as I said, which is a very vast area, because when you say civil action goes to several aspects and several kinds of actions. So I don't think I will have time to explain all that today. So I will go by these general matters where the lawyers should be really concerned about when they are drafting plaints. So now coming back to the topic, as you know, the civil actions are instituted in the district courts, where the original civil jurisdiction is vested with, and the jurisdiction is granted to the civil courts by Chapter 4 of the Judicature Act, where you get under Section 19 all the civil, revenue, trust, insolvency, testamentary matters are the jurisdiction is given to the civil courts. And also under Section 20, you will see the custody of persons and estates of idiots, persons of unsound mind, are also given to the district courts. And also you would see that under section, according to Section 21 of the Judicature Act, where the testamentary jurisdiction is given to the original district courts, where it has been repeatedly held, when a person dies, it is the duty of court to see as to how the estate of the deceased should devolve. So that is also a matter where original jurisdiction or original civil jurisdiction is exercised. And also you would see that that under Chapter 5 of the Judicature Act, you get family courts. But since there are no family courts in Sri Lanka, the jurisdiction of family courts are also exercised by the district courts of Sri Lanka. So the jurisdiction in family court is, as you know, the matrimonial disputes, actions for divorce, nullity, separation, damages, adultery, a claim for alimony, disputes between spouses, parents and children, and as to matrimonial property, custody of minor children, dependence claim, guardianship, curatorship matters, and in respect of declaration of legitimacy and illegitimacy and marriage, adoption, are coming under the purview of the family courts, which are being exercised by the district courts. So basically, in the district courts, under the Judicature Act, those are the matters where the civil courts are getting power to hear civil matters. So as you know, when now all this, as I said, all these civil matters are being decided by the district courts island-wide. And now this topic is instituting civil actions. Now, as you know, when a client comes to you and discloses redress, you have to decide whether there is a cause of action for him to initiate civil action. Now, that is the first thing you have to do. Now, what is cause of action? The cause of action is defined like this. An action is based on a cause of action. The popular meaning of the expression cause of action is that particular act on the part of the defendant which gives the plaintiff his cause of complaint. The cause of action has been described as the entire set of facts that gives rise to an enforceable claim, and as comprising every fact which is traversed, the plaintiff must prove in order to obtain judgment. it does not comprise every piece of evidence necessary to prove each fact, but every fact necessary to be proved. Every fact which is material to be proved is entitled the plaintiff to succeed. Every fact which the defendant would have a right to traverse form of essential part of the cause of action. And cause of action is distinguished from action. The action is simply the right or power to enforce an obligation. It springs from the obligation which is simply the cause of action. Now, in our Civil Procedure Code, the cause of action is defined in Section 5. In Section 5, the Section 5 says the cause of action is the wrong for the prevention of redress of which an action may be brought and includes the denial of a right, the refusal to fulfill an obligation, the neglect to perform a duty, and to infliction of an affirmative injury. Now, you would see, now under Section 5 of the Civil Procedure Code, it has defined what the cause of action is. So you can see when a client comes to you, now if his grievance comes under any of these categories, then you have to decide now what is the action you are going to file and whether you are satisfied with the instructions your client has given in respect of the cause of action. Now, when I say that, now you must always understand that there are certain restrictions, I should say, even if there's a cause of action, whether a person can go ahead with such a cause of action. Now, for instance, I would like to bring to your notice Section 24 and 23 of the Interpretation Ordinance. Now, as you know, the Section 24, I will read Section 24(1). Nothing in any enactment, whether passed before or after commencement of this ordinance, shall be deemed to confer upon any court jurisdiction to grant injunctions or to make orders for specific performance against the state, a minister, or a deputy minister, upon any ground whatsoever. And it goes on about the government servant as well. So, now what does Section 23 of the Interpretation Ordinance says? Now, Section 23 of the Interpretation Ordinance says, subject to the provisions of Section 24, where a court of original civil jurisdiction is empowered by any enactment, whether passed or made before or after the commencement of this ordinance, to declare a right or status, such enactment shall not be construed to empower such court to entertain or to enter a decree or make any order in any action for a declaration of right or status upon any ground whatsoever arising out of or in respect of or derogation of any order, decision, determination, direction, or finding which any person, authority, or tribunal is empowered to make or issue under any written law. Now you will see, now this is a restriction where even the redress is there, but if it comes under one of these limbs, then it is obvious that the civil courts will not have jurisdiction to entertain any of those matters. Now, likewise, I would like to say, now, even I have come across certain cases where this cases where sometimes the actions are filed against local government authorities like municipal councils, urban councils. But there are certain instances where the local authorities, the local government authorities are exercising the powers of other bodies like urban development authority, road development authority, like that. So then Now, when those powers are delegated to the local governing body, they are exercising the powers of the original person who has granted them the power. So under section 23, you would see that that kind of actions are not possible. Now it had been decided in a case where it is reported in, I would like to bring to your notice, reported in BSL News 2/8/96, Mangala Samaravira and another versus Sun Power System, where their lordships have held on a careful examination of the provisions of the said section 23, it is clear that the legal effect sought to be given is to prevent a court from entertaining an action for declaration of a right or any ground whatsoever in respect of an order or determination made by a person or tribunal empowered by law to make such order or determination. The court is of the view that the prima facie the decision of the petitioners to disqualify the said proposal by the respondents appear to fall within the provisions of the said section 23. It appears that they have acted in their official capacity as empowered by law. So therefore, their lordships have refused to entertain that kind of a case. And also, I would like to bring to your notice, in the case of Attorney General versus Harsha, is also reported in BSL News 5/10/93, where it has been where a person filed action against the Director of Customs for seizing his goods on the basis that the seizure was wrongful and unlawful, and sought a declaration that the seized and forfeit is that the Director General of Customs and his servants to return the said consignment of goods to the plaintiff respondent and for damages. After an inquiry, which the submissions were made on behalf of both parties, the learned district judge, by his order dated 26/1/1993, directed that the said consignment of goods be released to the plaintiff respondent in a personal bond of 6 million. Their lordships have held, we are of the view that the learned additional district judge had no power to make the said order in view of section 24(2) and 23. So therefore, you will see that when a statutory body is enacted, given power under a law, that they can decide certain things and they can make rulings, then those matters cannot be taken to those matters cannot be taken by way of a civil action to a district court. Now that is coming from the interpretation ordinance. Now there are some other matters also where we have to be very thoughtful when you are instituting a civil action. Now that is the prescription ordinance. Now the prescription ordinance plays a very big role in civil litigation, because even if a litigant is having a very reasonable, valid cause of action, but still, if he's out of time, however much he's having a cause of action, that alone will not allow him to have a judgment against the people who have been made defendant in his favor. So you will see the prescription ordinance. Now the prescription ordinance, according to the prescription, the sections of the prescription ordinance. Now the section 3 has set out any dispute in respect of a immovable property, you have to bring within a period of 10 years. Now section 4. Now section 4 is for possessory actions. Now actually when we came into practice, there were a lot of possessory actions where you have to bring in within a period of 1 year, where the possession of the land, because they never had title, they didn't have any paper title, they only had possession. So if a person is dispossessed from his possession, then we have to bring action within a period of 1 year. But now for the last 1 or 2 decades, I have not seen this kind of action in the Western province. And you will see under section 5, the mortgage debt or bond, the mortgage debt or bond prescribed after 10 years. You will see according to the section. Then comes the section 6, where the actions are for partnership, deeds, written promise, contract, bargain, agreement or security upon promissory note and bill of exchange. Now, if you are initiating action on any of these matters, so you have to be careful that you have to file action within a period of 6 years. Now, if it is a check, from the date of the dishonoring of the check, you have to file action within a period of 6 years. If it's a promissory note, from the date the person who has promised to pay that money, he has not given, so you have to file action within a period of 6 years. So those are the limitations. And we see under section 7 of the prescription ordinance, to action to recover goods, rent, money lent, and without written security. Those actions will have to be filed within a period of 3 years. Now those are defined. And also according to section 8 of the prescription ordinance, no action shall be maintainable for or in respect of any goods sold and delivered, or for any shop bills or book debt, or for work on labor done, unless the same shall be brought within 1 year. So you will see that all these sale of goods disputes, the bills, the book debts, and all these matters where you have to come within a period of 1 year. And also you will see now, even there are a few authorities recently where it has been held, even a book debt come under this category, and you have to file action within a period of 1 year. And then we come to section 9 of the prescription ordinance, where it says, for any loss, injury, or damage, unless the same shall be commenced within 2 years from the time that you can initiate civil action and get relief. So therefore you will see now, when it causes damages, any accident cases, the damages are the damages arising from accident cases, and any other damage, even physical damage done by assaulting or any such way. Also the damage caused by any defamatory statement, publications, those things are also comes under this particular section 9 of the prescription ordinance. And unless you are going to institute the action within a period of 2 years, you will be time barred and your action will not succeed. So you have to be very mindful of the prescription ordinance and see whether your action is prescribed or not. Then the section 10 says, it says, term in case of actions not herein before provided for. Now, the earlier from section 3 to 9 has given certain kinds of litigation, but section 10 says the causes of actions are not coming under these categories. The same should not be entertained unless commenced within a period of 3 years. Now, that is a matter where you will have to seriously consider, and going by the decided cases and also decided cases and the law, you will see what are the cases which are not specifically mentioned in the prescription ordinance. Now, action for unlawful conversion of property. Action for unlawful conversion of property, now we have to bring in within a period of 3 years. Now, action for damages for seduction or promise to marry, and for damages, you have to bring within a period of 3 years. And for illegal seizure, claim for mercenary profits, malicious prosecution. Now, if somebody has been maliciously prosecuted in a court of in a criminal court, that person will have to bring a civil action for damages within a period of 3 years. And also it comes even the lawyers, to recover their fees, they can file action against their own clients within a period of 3 years under section 10 of the prescription ordinance, and that had been held in the decided case of 38 NLR 55. And and to recovery of purchase price of a transfer. Now that is also a matter once the transfer deed is written, and if the purchaser has not paid the entire money or the portion of it, then you have to file action within a period of 3 years to recover the purchase price. Then cause of action arising on the execution of a deed on fraud. Now we every day we see where the people are filing action asking for a declaration on various grounds that a particular deed is null and void. So that kind of a litigation has to commence within a period of 3 years. Now you must understand. That this time period is not going to take out the rights of the minors, because the minors' rights are not affected by these provisions of the prescription ordinance, because they have, since as long as they are minors, their rights are protected, and that is another area where it will take a long time for me to discuss. And also the litigation to revoke a deed of gift also comes under this section 10 earlier, but now as according to Act number 5 of 2017 and Act number 5 of 2017, now it has been enacted. Now under section 3, it says the court shall not entertain an action referred to in section 2, that is to an irrevocable deed of gift may be revoked on the ground of gross ingratitude only on an order made by competent court in an action filed by the donor in such deed against the donee to have the said deed revoked. The court shall not entertain an action referred to in section 2 unless it is filed within a period of 10 years from the date of execution of such deed of gift and within 2 years from the date on which the cause of action arose. So therefore, now there is a limit, because you can't file action to revoke a deed after the expiration of 10 years, most probably, because if somebody is in occupation of a premises for more than 10 years, under section 3 of the prescription ordinance, you get prescriptive rights after 10 years. And on the other hand, if the cause of action after 2 years of the date of the cause of action, if you don't complain of that ingratitude and file litigation to cancel a deed of gift, then you are time barred. Then also for informal agreements, the section 10 applies and the time period is 3 years. And the recovery of money paid under mistake, you have to file within a period of 3 years. Then a declaration that a notarially executed deed is null and void, you have to file within a period of 3 years from the date of execution of the deed. That is also decided in Ranasinghe versus De Silva, 78 NLR 500. And also under the Intellectual Property Act, appeals under section 182 comes under section 10, and you have to institute that action within a period of 3 years. So now those are the matters where you will see the time comes into operation, where even your client is going to have a valid cause of action, and if he's time barred, then you will not succeed. Now there are certain instances where the prescription ordinance does not apply. Now, for instance, now living in adultery has been decided is a continuing cause of action where it won't get prescribed. And also, when a Viharadipati of a temple sues to be declared entitled to the office, those matters are also not prescribed under the prescription ordinance. So those are the matters. And also you will see, now when you are filing litigation, filing a plaint in a court of law, now you have to take into consideration this prescription ordinance and the time period that you can institute this action. Now, you know, as you, the past few days that the entire country was locked down for more than 2.5 months. And there were certain instances where a lot of people could not file their litigation within the prescribed period. So actually now, according to the Gazette notification published by the Gazette notification dated 6th of May 2020, their lordships have made a rule that I will read it in Sinhala. 665 දරන අතිවිශේෂ ගැසට් පත්‍රයේ පළ කරන ලද 1990 ශ්‍රේෂ්ඨාධිකරණ රීතිවල 7 වන රීතියේ පටහැනිව කුමක් සඳහන් වුවද 2020 මාර්තු මාස 16 වන දින සිට ආරම්භව 2020 මැයි මාස 18 වන දිනෙන් අවසන් වන කාල සීමාව සැලකිල්ලට ගනු නොලැබිය යුතුය. So that means that entire period had been put out from all these requirements. Now similarwise, now if you are filing a civil action which you are time barred, then you must take into consideration section 44 of the Civil Procedure Code. The section 44 says, if the cause of action arose beyond the period ordinarily allowed by any law for instituting the action, the plaintiff must show the ground upon which exemption from such law is claimed. So now this is a valid ground where nobody could go out of their houses, nobody could go and meet their lawyers, nobody could go to a court of law and institute action. So you can always rely on this section 44. I think almost all the judges in this country will not hesitate to give the proper meaning of the section 44 of the Civil Procedure Code and allow the litigants to commence if they can excuse themselves as to why they could not come to court within the allowed time period. Now, having said so, the Civil Procedure Code, section 11 of the Civil Procedure Code says who can be a plaintiff. Now, as most of you all know, the plaintiff is defined in section 11, and it says the section says all persons may be joined as plaintiffs in whom the right to any relief claimed is alleged to exist, whether jointly, severally, or in alternative, in respect of the same cause of action. So the definition of plaintiff is given in section 11, and the definition of defendant is given in section 14, where it says all persons may be joined as defendants against whom the right to any relief is alleged to exist, whether jointly, severally, or in alternative, in respect of the same cause of action. So those are the people whom you can join as plaintiffs and defendants. Now, when you start litigation on behalf of for a client of you, then the next thing what you have to do is you have to prepare the pleadings. The pleadings. Why pleadings are necessary? I will put a slide. A plaintiff is the first pleading filed by a plaintiff which initiate a lawsuit. A plaintiff sets forth the relevant allegations of facts that give rise to one or more legal causes of action along with a prayer for relief. An answer is a pleading filed by a defendant which challenges the legal sufficiency of a complaint. An answer is a pleading which admits or denies the specific allegations set forth in a complaint and constitute a general appearance by a defendant. Now we will see when I come back to this topic of my topic. you will see the pleadings in civil actions take a major role. Now, there are two kinds of pleadings. The pleadings in regular actions and pleadings under summary actions. Now, you will see as per the section 7 of the Civil Procedure Code, it says the procedure of an action may be either regular or summary. Regular or summary. Regular or summary. So it will be easy. It will be easy for me to explain the difference between the pleadings of regular and summary, because according to the explanation given in section 7 of the Civil Procedure Code, it says where the Civil Procedure Code or any enactment specifically says the action has to be initiated by way of summary procedure, then you have to follow that particular action by way of summary procedure. And under section 8, save and except actions in which it is by this ordinance or any other law specially provided that proceedings may be taken by way of summary procedure, every action shall commence and proceed by a course of regular procedure as hereinafter prescribed. So you will see now, other than the actions which are being specifically stated in the Civil Procedure Code, all the other actions are regular actions. Now, according to the Civil Procedure Code, what are the actions which are commencing under the summary procedure? Now, you will see under chapter 39. Under chapter 39, that is action relating to persons of unsound mind. Now, the Civil Procedure Code specifically says that action relating to persons of unsound mind you have to initiate by way of summary procedure. Then, chapter 40, action for the appointment of guardians of minor children, that has to be initiated by summary procedure. Then you will see under chapter 53. Chapter 53. The chapter 53 is of summary procedure on liquid claims. Section 703 of the Civil Procedure Code. Civil Procedure Code. Those actions, as you know, those are the actions where you normally file for liquidated claims, like on checks or promissory note and bills of exchange. So those actions you have to initiate by way of summary procedure. And also you will see specific acts like adoption ordinance. So those actions must be instituted under summary procedure. And also you will see under section 608. Section 608, where the Civil Procedure Code specifically says application for separation mensa et thoro on any ground on which by the law applicable to Sri Lanka such separation may be granted, may be made by either husband or wife by a plain to the district court within the local limits of the jurisdiction and 680 and it goes on to say it was either spouse may, the headings are under A and B, then it goes on to say, apply to the district court by way of summary procedure for a decree of dissolution of marriage. So now that is where, and a normal divorce action is under the regular procedure, but if you are going to seek a dissolution of marriage under the provisions of section 608 of the Civil Procedure Code, then you have to apply, then you have to make an application under the summary procedure. And also the summary procedure is also described in chapter 24. The chapter 24 says how the summary procedure, how you can file an action under summary procedure. Now the requirements are given in section 374. If you carefully read section 374, you would see that you have to fulfill all the necessary mandatory requirements, and then you proceed with the summary procedure action. And then the other actions are, other than the regular actions, are the readings in procedural actions. Now the procedural actions are like testamentary actions under chapter 38, and also interpleader actions under chapter 43, the section 628 of the Civil Procedure Code. Now, when we come to the regular procedure, the plaint and it is requisites, that is, you will see that is the most applied provisions of the Civil Procedure Code in our civil courts. So you will see an action to institute by a filing, then under section 39 of the Civil Procedure Code, an action is instituted by the filing in a court of law a duly stamped written plaint. Under section 33 of the Civil Procedure Code, one has to make the pleading to afford ground for a final decision upon the subject in dispute, and so to prevent further litigation concerning them. So that means that if you are going to initiate an action, you must see that the entire matter between the parties. Request of reading. I will put a slide where I'm reading now. I think I did not have all this time. Yeah. The section 34, under section 34, every action shall include the whole of the claim. If you read the carefully section 34, you see. And section 34(2) says, if plaintiff omits to sue in respect of or intentionally relinquish any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. So those are the basic requirements which you have to do before settling the plaint. So you have to take all this into consideration and prepare the plaint. Now, how the plaint has to be done is in section 40. Now you see the section 40 is the most important provision, where it says the name of the court and date of the filing of the plaint has to be there. The name, description, as you know, the place and residence of the plaintiff. The name, description, and the place of residence of the defendant, so far same can be ascertained. Now, as far as the plaintiff is concerned, the plaintiff has to give the precise place of residence. But as when the defendant is concerned, that is why you see in a lot of cases where defamatory actions are filed, where the reporter or the editor's address is also given as the publisher's address. So that is the cover they are taking, because it says so far as same can be ascertained. And then the most important provision in section 40 is section 40D. Section 40D. You see the section 40D says a plain and concise statement of the circumstances constituting each cause of action and where and when it arose. Where and when it arose. This is the most important thing. Such statement shall be set forth in duly numbered paragraph, and where two or more causes of action are set out, the statement of the circumstances constituting each cause of action must be separate and numbered. Now this when and where is a very important provision, because now there are, if you omit to put as to when the cause of action arose, and that is a fatal error. Now it had in the case of Leslie Silva versus Pereira, reported in 2005, 2 SLR 184. His Lordship Somovan sir has held like this. In terms of section 40D, the plaint should contain a statement as to where and when the cause of action arose, and is not a fact which should be kept to be disclosed at the trial. The plaint, it is apparent, does not say as to when the purported action arose. No other evidence documents are required to decide whether the plaint is drawn out in compliance with section 40D. This is a fatal defect which goes to the root of the case. Now you will see when it had been decided, and I have seen in my practice also very many cases where the litigants, the lawyers are filing actions without giving the date where the cause of action arose. Maybe to smuggle in a date at the trial, or maybe for any other ulterior motives, or maybe on the face of it, the plaint is prescribed. But to omit, to include when and where the cause of action arose is now fatal. And on that fatality alone, the plaint can get dismissed. So you have to be extremely careful on that particular point. And you will see, now there are certain other things. There are certain other things that you have to be concerned of. Now section 44, if you are suing on a land, then you have to describe the metes and bounds by a sketch. And if the plaintiff, under section 42, if the plaintiff is suing on the capacity of a representative capacity like an administrator or a trustee, then you have to disclose your character. Then section 43 says the plaintiff must show the defendant interest and liability to be sued. And section 44 I discussed earlier, and also the section 45 is also a very, very, very important section where you have to avoid the jurisdiction of court. That is a very necessary thing. And I would like to say now, jurisdiction of court to be avoided by a statement of facts. Now, in the absence of, because you will say in section 45, every plaint shall contain a statement of facts setting out the jurisdiction of court to try and determine the claim in respect of which the action is brought. And I know a certain case where a retired Supreme Court judge was filed an action. He filed an action, and in that particular action, the jurisdiction was not pleaded. So I'm telling you that. But then he complained against that lawyer. He was a good friend of his, and ultimately the instructing attorney who filed that plaint was debarred. And I'm telling this because both the retired Supreme Court judge and that lawyer is no more among us. So you can see how dangerous it is to not to include the jurisdiction of the court in a paragraph. So these are basically, if you see that it sees as a technical defect or a procedural defect, but those things goes to the root of the case. And you will see in those instances where the plaint can be rejected on those grounds alone without going into the merits of the case. So you must know, actually I'm running out of time. I think I'm running out of time. So because of that, I will say now these are the broad things. These are the broad things where you have to be really concerned and mindful of when you are having litigation. Because you must always understand, though a litigant comes to you, taking your expertise or legal knowledge for them to sort out their legal issues, if you do a small mistake, if you do a mistake, small or big, it doesn't matter, they are going to complain against you. They are going to, because they are coming with redress. They are not allowing you to compromise in any way. So that is the very reason why you have to be very mindful when you are drafting claims, especially in civil litigation, because the civil litigation takes a long time, and at the end of the long time, nobody wants to have litigation. Can I have my picture? Yeah. Now, when somebody wants to have a litigation, now they don't want to go ahead with the litigation and lose that litigation for no reason, for a technical defect or a procedural defect. So you have to be very careful and mindful always when you are drafting papers, because as I said, even if the pleadings are wrong, there may be certain instances where you could withdraw the case and file a new case, but most of the time, by the time you realize, the time is gone. So therefore, when you are drafting papers, you have to be extremely careful. You must be mindful to go into minute details and exactly identify the redress, and also to identify the cause of action, and then draft the papers. I think I'm running out of time. Vijay, am I having any questions?
So there are a few questions you can have for another 5 minutes to wrap up if you want.
Oh, okay. No.
You can have another 5 minutes to wrap up, and then we'll go to questions.
No, actually, I went in details now, because if I get an opportunity, I will go into other details of the plaint and the answer, the replication, and if I'm in a future date, I think I might be able to explain those things and the request of those matters as well. So rather than trying to summarize what I have been telling all this time, I will go to any of these questions.
Yeah, there's a question, sir.
Yeah.
With regard to ejectment, the prescriptive period is 10 years.
Yeah.
Otherwise, it says in an action for ejectment, if it is not filed within 10 years, it would be prescribed. Is that position correct?
No, that is not correct, because that is not correct, because ejectment, most of the time the ejectment cases are being filed if it is a rent and ejectment matter, because he has gone into occupation of the premises as a tenant. So once he entered the premises as a tenant, he can't change himself, he can't change his status while being inside as a tenant. That there have been a lot of decided cases on those on that matter and authority. So therefore, a person who goes into a occupation as a tenant, he continues to be as a tenant. But if he is not paying rent and if he is not fulfilling the basic requirements of a tenancy agreement, then he's a trespasser. Again, the trespasser is also continuing trespasser. So he can't claim prescription after 10 years. Then in that event, he has to go out of the premises and then come back again and say, I'm here as of my own right. So there are decided cases. So the tenant, overstaying tenant, is a continuing offense and it is not prescribed after 10 years.
If it is not for a tenant, rather, if it is a, say, a trespasser.
A trespasser, okay, right. A trespasser is like this. Now, even now, it is the time now, if a trespasser has gone into a land, and then you have started litigation. So if you have started litigation, then you are disturbing his possession. You are trying to exercise your legal rights. So from the date that you have initiated action, his prescription stops. The time period for his prescription stops from that time. So you are, even if it is going to litigation is going to take more than 10 years, you have already challenged his position and you have already put the title of the rights of the parties to be decided in a court of law. So then the prescription is not running.
Now, sir, now for a defendant, now I gain from this question is, if the defendant want to claim prescription for 10 years, is the existence or the pendency of a 66 matter in the magistrate court and thereafter the high court and lastly in the Supreme Court.
Yeah.
that period will be considered as a time of prescription, or that will be excluded?
No, no. You are talking about the case where there had been regarding the position in the magistrate courts.
That's right. Section 66 matter.
Right. Okay. Now,
So,
if the 66 matters are different, because 66 matters,
no,
the
no,
judge,
sir. No, it is not that. The question is whether that time period of pendency of section 66 matter is considered for the calculation of 10 years of prescription or not.
no, because you have litigated, you have started the litigation. Because you have started the litigation undisturbed, uninterrupted. So once you, because the requirement is for undisturbed, uninterrupted. So you are disturbed, you are interrupted. If a litigation is commenced, one can't say I'm in undisturbed, uninterrupted position.
Right. Okay, sir, we'll move into the next question. What are the reliefs available to stop wrongdoing committed by local authorities exercising power of the bodies? So when a local authority is exercising, or rather they are exceeding their power, is there a civil remedy that is available for the parties to sue in the district court or other civil court?
Now, actually, the thing, actually the local authorities are governed by municipal council ordinance or the urban council ordinance or the village council ordinance, right? So if those councils are exercising any power, now for instance, approving of a building plan is completely with the purview of the urban development authority. Yeah. Now, if that power had been delegated to the commissioner or to a specific officer by a certain gazette notification. So when they are exercising that power, and if you are having a grievance regarding that kind of a matter, then you can't go to civil courts. Then you have to go to the appellate court and challenge the decisions. But on the other hand, where the municipal councils are doing certain things as empowered by the municipal council or the urban council act ordinance, then those acts you can file action in the district court where that particular council is situated. Now, for instance, now you will see, now there are certain requirements that you have to file, you have to undergo under section because if you are filing action against the municipal council, then you have to give notice under section 306. Under section 306. No, there's a section I can find that section where you have to give 1 month notice to the 1 month notice to the municipal council. So after giving 1 month notice to the municipal council, without giving 1 month notice to the municipal council, you can't file action. And on the other hand, you have to file under the municipal council ordinance, you have to file action within a period of 3 months from the date of the cause of action arose. So those are the requirements that you have to do. And also there are judgments to say, now if a municipal council or if the municipal council employee has done something which he is not empowered to do, then the provisions of the municipal council act will not apply to them. So that is also a matter that go into and see whether in fact they were empowered to do that or not. Now that is a very I think there is a case. I think there was a nine judge nine judges of the Supreme Court has held in the case of NLR, I think 80 NLR 1. The capacity of the thing what they have done. I think I'm right. I think it's 80 NLR1. So, if you are filing any action against the municipal council, only thing that you have to abide, you have to uh, comply those mandatory provisions under the municipal council ordinance, and then you can commence the litigation in the district court. They are municipal councils are not coming under section 23 of the interpretation ordinance.
Hello. Sir, can we move into the next question?
Yeah, what is the next question?
Yeah. Next question is, what are the limitations on application of prescription ordinance? Are there any limitations for the prescription ordinance application? Prescription is a limitation for the action. On the other hand, are there any limitations for the prescription, application of prescription?
Yeah, of course, yes, there are, because see now, as I said, minors are not governed by the provisions of the prescription ordinance. Then, as far as even the state is under the prescription ordinance, though normally the state is not under prescription ordinance, where there is a case where the action was filed by the state for damaging a state vehicle by the defendant. So the defendant took up the position that the action is prescribed. So then the apex courts held, though the state can't take up the of defense that the prescription ordinance is not applicable. So therefore, in that particular case, it was held that the state is also under the provisions of the prescription ordinance in that kind of a issue. So, and also the minors are not coming under prescription ordinance. Then the state lands are not coming under prescription ordinance. How much ever you are going to occupy a state land, those are not coming under the prescription ordinance. And also under the Buddhist temple ordinance, even if a person is going to possess land which belongs to a Buddhist temple, that person will not claim the rights under the prescription ordinance and say, no, I have been in this position for more than 10 years, therefore I'm the owner. That is not possible. So those are the on the face of it, those are the things that where the limitations are being taken out.
Yeah. One last question. I think you can simply give an answer, sir. This is about about the testamentary proceedings, the section 528(1), the 3 months period given for instituting testamentary actions. The question is whether it is mandatory or only a directory provision, and whether any violation or failure to go to court within this period makes any bar or any infirmity to the petitioner in such an action.
No, actually, this is actually we come across this situation very often. We come across this situation because actually about 1/3.
It's not clear.
Hello. Actually, we
Yeah.
this kind of situations. Very often we come across this kind of situations because I think about 1/3 of the testamentary actions which are filed
After the time period.
now clear. Oh yeah, sorry. 1/3 of the testamentary actions which we are filed are out of time.
Yeah.
So actually, then again, now according to the wordings of section 528, it is mandatory. Now, every application to district court for grant of letters of administration or for the issue of certificate of heirship shall be made within 3 months. Now, again, you get the help of section 44 and you say a lot of things like, we did not find the last will, we could not find the property, we did not, there was an issue with the heirs and the deeds of the properties. So these kind of excuses are always given. And actually, that the section is there, but my view is that the judges are taking a very very lenient view when a person comes to court and say, now this is the reason why we should not come to court, simply because the courts are vested with the jurisdiction to do justice to a disease. That is why in all these, almost in all the decided cases where on last ways, it had been decided the court must jealously look, jealously, the word they have used is jealously. So that shows what is the duty cast upon court in respect of a person who is dead. So, you know, always the courts are taking a lenient view, and they are trying to allow the people to come before court and to do this litigation so that the disease interest will be correctly looked after. So you always take the, you know, cover from section 44 and say this is the reason why we could not file this action within the period of 3 months. So that is the only way that you can go out. But I have not seen any very many actions where the courts have decided only upon this matter, where the courts have dismissed this application saying that this is time barred and you are not allowed to come.
Yeah. That brings the end of today's webinar lecture. Our president, Mr. Wijayaweera, is usually propose the vote of thanks, but today is not available to propose the vote of thanks. So on behalf of the president and the Colombo Law Society, I take this opportunity to thank Mr. Priyal Wijayaweera, President's Counsel, who accepted our invitation with a very short notice and got ready and did a very fruitful discussion. And as you said, sir, it will be very useful for the young attorneys as well as to the law students. The material that you have shown, or rather the slides, we will obtain from you, and we'll try to put it on our website. And while thanking for your time, I really appreciate on behalf of the Colombo Law Society, and we hope to continue this Friday evening webinar series for some future time. And we will certainly get your assistance and your resource in future as well. And this marks the end of our fifth webinar. And while thanking for all the participants who attended and posed questions, I will now mark the end of this event. And next week, we will come out with a new topic, and we will be informing you with our normal communication tools soon after the weekend. Thank you, and have a pleasant weekend and an evening. Thank you very much.